Hello, my name is Ron Dimock, and I'm an intellectual property litigation partner in the Gowling WLG office in Toronto. It is my pleasure today to have Professor Randall Rader as my guest for the next half hour or so to discuss what else? Patent law. But first, to get some formalities out of the way. I could call you Professor Rader or Judge Rader, but today I will call you Randy for short. How's that?
Thank you. That's just great, Ron.
Okay. Well, welcome, Randy, and thank you for doing this. As I read about you and know you for many years now, you were born in Nebraska, grew up in Oregon, went to university in Utah and studied English as a major, and then you went to law school in George Washington. So you moved around. You now teach patent law at some of the prestigious universities in the world, such as your own alma mater. You are an author or co-author of many patent texts, including one of the Nutshell collections. But I should mention that you sat on the U.S. Court of Appeals for the Federal Circuit for over 25 years and served as the chief judge before retiring from the bench in 2014. Since then, you founded the Rader Group, focusing on arbitration, litigation, mediation, and legal consulting. But more than that, Randy, you are a musician, a rock and roll cover band, and aspire to be on the cover of Rolling Stone. And rumor has it that early on in your musical career, you considered joining the 60s rock group Paul Revere and the Raiders.
Well, they auditioned me. I don't think I made the audition.
So we don't have to debunk that rumor. It's true. Okay. But since leaving the bench, you have been extremely busy, and seemingly for you, kicks are not getting harder to find.
Good song.
Good song, yes. Now, while harmony is music to your ears, harmony in patent laws is dear to your heart, as I understand. Is the rest of the world getting closer to harmonizing patent laws, Randy?
You know, I'm a little disappointed in the United States. We've been the one that's been diverging. For many years, we diverged in the area of first to file versus first to invent.
Yeah. We
finally solved that problem to a degree, and now we're creating other ones.
Yes. Well, as you've written before, the world is trying to solve several problems in patent law, and one is how to put a proper value on patents. Has the world succeeded there, like the first to invent aspect?
You know, Ron, I really believe that this is the key to make the whole system work. There is apprehension about whether patents on small components in larger machines are sometimes overvalued. But you know, if you got the right value on every invention, there wouldn't be problems. We could rent them out through royalties seamlessly, and litigation could become a secondary consideration.
That sounds like it needs sort of a very broad brush stroke by organization, and a sort of a trend towards more analytically sound methodologies in determining a value of a patent for deciding the quantum of damages for infringement, for example.
Well, you know, these are difficult principles, but we do have tools. We have the cost method, which is looking at comparable licenses or established licenses. We have that's actually the cash method. The cost method's looking at how the technology has saved some economic value over the prior art. And then, of course, there's the market valuing system where you look at the demand created by the claimed invention. I think if we could somehow work to bring those closer together so they produce the same valuation, yes, I think we could achieve that broad brush stroke of making the system work better through proper valuation.
Yeah. In trying to harmonize the world, there are certain laws in some countries that have changed, but some have stayed the same for many years. I know in the United States, you used to have an accounting of profits for patent infringement many, many years ago. And in Canada, for example, we have an accounting of profits, and recently we had the largest award of money in an accounting of profits in a case between Dow and Nova. I'm not suggesting that the world go to an accounting of profits, but that's one way of making a patent far more valuable than it might be at the present time.
Yeah, that's can be a very effective way when you're in a smaller 2-supplier or 3-supplier market, where you're relatively confident that any sale that the infringer made would have been made by the patent owner. But that is not the general outlook of the marketplace today. You usually have to account for a vast array of non-infringing substitutes.
Yeah, well, all right, we wanted to get through a number of different issues today, and I think we've done a pretty good job in that first one on harmonization and patent value. But I know one issue that really is important to you and has irked you recently, and that's the patent eligibility or patent subject matter. And you've written about that the United States, for example, is now out of step with Europe and Asia, where at one time, the United States would recognize, I think one of your judges said, everything under the sun is patentable. Everything new under the sun is patentable. But the recent, or I wouldn't say recent, it was about over 6 years ago, there was a case decided by the Supreme Court of the United States that you thought was wrongly decided and has caused a sort of a backward step in deciding patent subject matter. Perhaps you'd like to comment on that.
Well, there's 2 problems in this area here, and you're right on, Ron, that this is an area where the United States is completely out of step with the rest of the world. And that's very disappointing because in the first place, our statute is broader and more receptive of all fields of technology as being eligible for patenting than any other law in the world. We have the one that, if it was followed, would not only keep us in harmony, but perhaps set a standard for the rest of the world to achieve too. But that's one problem, is that the courts have misconstrued and not followed the law given to them by Congress. The second problem has been that the Supreme Court, I think, really kind of delegated this issue to the Federal Circuit and hoped that they would use a scalpel to carefully distinguish between cases that really don't warrant further patentability inquiries and those that do. And instead, I think the Federal Circuit, to my dismay, has used a bit of a sledgehammer and instead of drawing careful little lines, has just kind of thrown everything aside. Again, the Supreme Court didn't give them a lot of guidance, but I'm disappointed that the true patent experts haven't used that scalpel instead of the sledgehammer.
So I take it that Alice still lives in the United States.
No, it does very much so. It not only does it live, but it disrupts. Sometimes things are eligible and the same technology with the same amount of clear, concrete, practical application is ineligible. And it's just, that's not really tolerable in any system.
Yeah, in Canada, we're going through the same angst as to how to decide patent subject matter when it comes to business methods or inventions that utilize computers. And our federal court recently sent a patent application issue back to the patent office to look at it differently, to apply a standard which the court thought should allow for the invention to be the proper subject matter of a patent. So we'll see there. Now, you mentioned about the Federal Circuit not following suit with the Alice decision of the Supreme Court of the United States. Can the Supreme Court make amends with the upcoming, as they call it, the garage door case?
Well, I hope so. Yeah, you mentioned the garage door case. I actually wrote a brief for the court on that, in which I suggested here is a classic example of a concrete machine and its operation. And so it isn't really abstract at all. And remember, that's the principle they're using to say it's ineligible, that somehow a garage door opener is too abstract for patenting. That's hard to comprehend by anyone.
Yeah. Well, maybe they'll close the door on the Alice decision.
Yeah, we'll hope so.
Let's hope so. It's something that I think is a very important issue, because if you don't have a patent, then you don't have the exclusive rights to protect your invention. And as you've written and talked about it before, we really need innovation to spur our economy, and patents do allow for incentivizing the development.
You're kind of taking us in a direction of remedies, Ron, that once again, our courts have had trouble with the proper remedies for patent infringement.
Well, we've talked a bit about damages and so on, but I guess the other remedy that is important for a patentee is to enforce the exclusive rights that are attached to a patent, and that's getting a permanent injunction.
It's this simple, Ron. When someone trespasses on your property, the remedy is to remove the trespasser. You can talk about damages. That's important in a commercial law sector, but you know, the first and fundamental remedy has to be to remove the trespasser.
Yeah. Well, we all know that there's no longer an eBay on the internet, but there's still an eBay in your patent law. And although it has been altered, and particularly by one of your decisions, the Douglas case, but tell me about eBay, and is there a fundamental flaw in the analysis?
Yes, there is. Now, in eBay, the Supreme Court seized on the use of the word may in our statute, which says that even after a finding of infringement, a district court may impose a permanent injunction. And they thought, well, if they use that discretionary term, we're going to throw it open to a four-factor test. And that has led to enormous confusion in our law and a decline in the general rule that you ought to remove the trespasser. And the problem is the court didn't recognize why the word may was there in the first place. The word may had to be there to accommodate a threat to public health and public safety, which might otherwise occur. My favorite example here, Ron, is a heart pacemaker. And so you find out that this new technology, the pacemaker, is infringing. Well, you're not going to stop it. There's an instance where a judge would step in and say, due to a threat to human safety, we're not going to impose the remove the trespasser rule. The other example, that, by the way, that's a real case. The other real case that comes to mind is a wastewater treatment plant. Again, that technology, if it's infringing, we're still not going to shut it off. And if you recognize, however, that that may is there only for those severe cases of threat to public safety, then the trespass rule continues to work, where you remove the trespasser in any other situation after they've had a full chance to prove that the patent was not valid or they weren't infringing. They are trespassers, they should be removed.
Well, in the United Kingdom recently, we had the decision of the UK Supreme Court on the SEP case involving the
Unwired Planet.
yeah, and they reinforced the idea that patents give the patentee an exclusive right, which can be enforced with a permanent injunction. In Canada, our Federal Court of Appeal, the equivalent of your Federal Circuit, if you want to call it that, said that it's rare not to have a permanent injunction when a patentee succeeds at trial. So with the eBay case, the United States sort of stepped out of harmony with the rest of the world. But I think you tried to sort of wrest it back again in the Douglas Dynamics case, did you not?
We did. It hasn't succeeded so far because we still have a lower injunction rate down below 75%. So, and it's still applied in a very fuzzy manner. They apply this no injunction rule according to the characteristics of the party. Well, that should never be a factor that influences the law. The law should not be judged and changed based on whether you're a big company or a small company, whether you're a clinic or a university or what. The nature, the characteristic of your business should not influence the enforceability of your property rights.
Well, you talked about the nature of the patentee, and you know, we've heard about trolls, wreaking some havoc on some patent portfolios in the United States, not so much in Canada because our market is smaller and we do have costs that are awarded to the victor in a patent case. Has the courts in the United States taken account of trolls and perhaps have started to award costs decisions?
This is more available now at the discretion of the district judge. They can award costs. Sadly, they've moved instead in the direction of not giving a proper remedy. And that, again, is penalizing parties according to their characteristics, not according to their legal proof. And that's disturbing.
Well, as I said at the outset, you're now doing arbitration work. And we're all trying to do arbitration work at our late stages of our careers. But I see, and I'd like to have your comments about this, that arbitration of some international patent disputes might be the way of harmonizing some of our laws or some of the results that one can get from enforcing patents around the world. Has that sort of got any sort of germ of a good idea to?
Now that resonates with me very much, Ron, particularly in the standard essential patent area where you often have competitors licensing each other's portfolios that are incorporated into a standard, and it avoids the anti-suit and the anti-suit injunctions and the very complex and difficult market-to-market enforcement, such as you see evidenced in this Unwired Planet case. So I think that arbitration may be a big part of the answer to that problem.
Yeah, well, I think alternative dispute resolution has its place now because of the costs of doing patent litigation, and because we're a flattened world, according to Friedman, that there is infringement around the world of some patents now, and I think we need to have a broader brushstroke, and maybe through arbitration we can, as well as through the harmonization methods that you described earlier. I'm hoping that one or both will succeed. We'll have to wait and see, Randy. What issues do you see coming forward in the next few years that will have an impact on patent harmonization or our patent laws in the United States and elsewhere? Is there any?
Well, I think some of the biggest moves in favor of a world harmonization are going to be taken in China and Asia. And you already see, for instance, that China is, through its trade agreements, adopting some kind of a linkage system like our Hatch-Waxman Act. They call it an expedited remedy instead. But I think maybe the initiative for harmonization may shift to the Asian markets.
Okay. I'm impressed in one respect with your patent system in the United States, in that the Supreme Court does seem to be interested in giving leave, as we would call it, to appeals from decisions of the Federal Circuit. Perhaps for some of those who may be interested and don't know, could you explain how one gets from say a district decision of a patent judge to the Federal Circuit and then to the Supreme Court of the United States?
Yeah, see, the interesting difficulty in a Federal Circuit decision is that there's no competing circuit court to which you can compare the Federal Circuit's doctrines. And so you have to just look for instances where there's enough confusion internally in the court for the Supreme Court to act. I think that's very apparent in the eligibility area that we discussed earlier. I think there's a coming area of enablement where the court has had some doctrines trending away from the international norms. And again, I'd love to see some kind of a patent valuation emphasis that would bring us back to the commercial roots of this law and really make it work.
Yeah. Well, I've been in practice as long as you have, and so I've seen a lot of changes. And one of them was, at one time, corporations would come to Canada to fight their patent lawsuits. Xerox versus IBM, Polaroid versus Kodak in the 70s and early 80s. And then along came your Federal Circuit, and that seemed to change things for the United States patent system. There was more attention given to the value of patents. Intellectual property became an acronym, IP, and then so on. And what role do you think the Federal Circuit had in giving more value to IP?
No question that the 1982 creation of the Federal Circuit breathed life into intellectual property worldwide. And the Federal Circuit, for at least a couple decades, was the leader in intellectual property thought. That's why it's so saddening to see the court leading some of those doctrines out of a posture of international harmony.
Yeah. Well, before we finish today, I do want to thank you for something you did for me some time ago, and that is deliver one of the first Fox lectures in Canada. And
That was a joy. I remember it well.
yeah, and you came to Canada to give that lecture in the middle of winter. And you also decided the championship moot for Canadian universities on IP. And there was a bench of 5. I think you sat with one of the judges of the Supreme Court of Canada and 3 other appellate judges. I wonder whether or not we should try to get to an international moot. I know Oxford has one. It would be, I wonder whether or not you've been involved in any other moots since then.
I have on occasion. Maybe we ought to talk to our fellow brother,
yes,
Sir Robin Jacob over in London, and see if we can't pull something together like that.
Well, let's try to do that. But I do want to thank you, Randy, for taking your time, as busy as it is, to talk to me today, and for giving your candid comments about issues in patent law. Thank you very much, Randy.
Thank you, Ron. I hope we get together often.
Okay, thank you. Bye-bye.
Bye.